Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This podcast will be about 10 minutes long. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is Feltman versus 106 Realty, a fairly recent Supreme Court New York County case. First, let's set the stage with some context. In this episode, you're going to hear me talking about rent stabilization, but you free market tenants don't tune out because your expensive free market apartment might just be rent stabilized and your landlord might owe you an overcharge award, and that's part of what today's episode is about. When an apartment enters rent stabilization for the first time, how is the first rent set? Usually, the rent of a new rent stabilized apartment is not an affordable rent. Remember, rent stabilization is not a needs-based program. Sometimes it works out that way, like for a percentage of the affordable component of a new 421A project. But in general, the very first rent for an apartment just entering rent stabilization is the free market rent for that apartment. But thereafter, the rent will only increase by small annual or biannual rent guidelines board increases. That's why it's called stabilization, because the rent remains pretty stable. It does not ever shoot up arbitrarily like a free market rent might. So if a new apartment gets created within an existing rent stabilized building, then that apartment's first rent is the market rate rent. You might ask, well, how do you create a new apartment in an existing building? You could, with the proper permission from the New York City Department of Buildings, build up on the building or build back into the building slot, but there's also another way. As of this recording in late August 2023, a landlord can take two apartments in a rent stabilized building and combine them into one big new apartment, an apartment that never existed before. So for example, landlord could take 1R and 2R that's directly above it and make a duplex. Or landlord could take one big apartment and break it into two little apartments. For example, landlord could take a 2-bedroom apartment and create 2 studio apartments in its place. When landlords have made these kinds of changes, the courts have, so far as of this recording in early August 2023, reasoned that such actions create a new apartment, and that new apartment gets a first rent at the market rate. But we have to think about, why would a landlord bother with this? So let's just follow the money for a second here, people. Let's do some math. Let's say we have 2 empty rent stabilized apartments sitting next to each other, and the rent for each is $900. Now, the landlord can get some increases on vacancy. Just to make the math simple here, let's say the landlord can get $1,000 for each of these rent stabilized apartments sitting next to each other. So if he rents one apartment to somebody for $1,000 and the other apartment to somebody else for $1,000, the landlord's going to get $2,000 a month. But if landlord spends, let's say, $25,000 to combine these 2 apartments and create a brand new 2-bedroom apartment, an apartment that never existed before, that's considered a new apartment, now landlord can get a first market rent. And let's say for a 2-bedroom in the right neighborhood, he gets $4,000. So instead of getting $1,000 plus $1,000, which is $2,000, for the same exact area, he's getting $4,000. So landlords increased its profit by $2,000 a month. And after 12 months, the landlord's basically paid itself back for the $25,000 investment in combining the apartments. And now from there on is just making way more money on the building. So that's what stimulates landlords to go in this direction. But unfortunately, not all landlords have followed the rules when engaging in this new apartment first rent practice, and many tenant advocates have questioned whether the practice should even exist. I mean, we're in a housing crisis, so how does it make sense to take 2 affordable apartments and change it into one not affordable apartment? So anyway, the legislature, the New York State legislature, has passed Senate Bill S2980C. I'm going to put that in the show notes. That passed the Senate on June 9th, and it passed the New York State Assembly on June 23rd and was delivered to the governor on June 30th. If the governor signs this bill, and I don't know if or when she will, but if the governor signs this bill, then this whole practice of new apartment first rents will be eliminated. And going forward, landlords will no longer be able to engage in this practice. But whether or not the governor signs it, I still think we're going to see a lot of cases in this area because I think this has been a very abused practice. And that brings us into today's case. In today's case, we see a tenant suing the landlord in state Supreme Court for a declaration that the apartment is subject to rent stabilization. The landlord says the apartment was deregulated because in the past, the rent was high enough to reach a deregulation threshold. Now, we don't have deregulation thresholds anymore, but back when we did, the landlord said that the rent legally progressed to the proper deregulation threshold, and thus the apartment's no longer rent stabilized. And one of the reasons the rent got so high was because the apartment is a new apartment that was entitled to a new apartment first rent. The landlord had gotten approved plans from the New York City Department of Buildings, and he put those architectural plans into evidence, and they showed that interior walls were demolished and an exterior wall was expanded, but apparently only slightly. So I guess what happened here is a former common area storage unit was incorporated into the apartment as a whole. So the landlord was not taking two separate apartments and making them into one. Rather, landlord just grabbed some, I guess, space from a hallway and included it into the apartment. So the court ultimately held that to allow a landlord to significantly increase the legal rent on a rent-stabilized apartment merely by modifying the unit's dimensions in a minor manner is improper and does not lead to a new apartment that's entitled to a first rent. Here, only one exterior perimeter wall was slightly expanded and a wall inside was moved somewhat. So the original apartment was not obliterated, a new apartment was not created, and so a first rent was not something that the landlord was entitled to, so the rent didn't really advance. So the court ended up pushing the apartment back into rent stabilization. And there's a lot of appellate case law that supports the way the court went here, although I checked on the court's website and it looks like that maybe the landlord is appealing this. I don't know. In any event, I believe that there are a lot of broom closets and storage areas and little pieces of hallway added into existing apartments out there in the name of new apartment first rents. In June 2019, the Housing Stability and Tenant Protection Act eliminated landlords' ability to get big vacancy increases on rent-stabilized apartments. So if you put together the big upside that this new apartment first rent thing creates, combined with less landlord options to increase profit legally, combined with the fact that it's hard for tenants to figure this whole game out, it's led to a great deal of landlord interest in new apartment first rents in the last 4 years, and I think a great deal of abuse. So now in our tenant takeaway, we're going to discuss how you can figure out if your apartment is a new apartment first rent situation. Tenant takeaway time. How can you figure out if you are in a new apartment first rent situation, and what does it mean if you are? Well, if you are, and the landlord did it improperly, as we saw in the example in today's case, it could mean that your free market apartment is actually rent stabilized and maybe you're entitled to an overcharge award. If you're already rent stabilized, it could mean you're entitled to an overcharge award. Now, whether or not the landlord did it correctly, that's a question that you can't even begin to answer unless you first know that your apartment is in a new apartment first rent posture. So that's the first thing to figure out. Also, if the governor does sign the law, there's going to be some landlords for a period of time, there always is after the law changes, that are going to keep doing this practice, even if it's forbidden. So in that case, just the fact of the change will give rise to landlord liability. But like I said, if you don't know that a new apartment first rent situation even occurred, then you can't even question if it was legitimate. So first you have to figure out if it happened. So here are 4 tips to figure out if your apartment is a new apartment first rent situation. And none of them are slam dunks, easy ways, but this is where you start looking to put the pieces together. Number 1, check at the New York City Department of Buildings to see if there was construction on the floor of the building where your apartment is located. I'll put that link in the show notes. Number 2, check with the New York State Division of Housing and Community Renewal, the DHCR, for your apartment's rent history. I'll put that link in the show notes as well. If your apartment's rent history just recently came out of nowhere or doesn't exist at all, that could also be a hint that your landlord is treating your apartment as a new apartment first rent situation. Number 3, did the landlord give you an RR1 form when you moved in? This is the form that a landlord is supposed to give the first tenant in a brand new rent stabilized apartment. Number 4, does it look like your apartment was weirdly extended to encompass what was once a broom closet? Or does your apartment look like it was chopped up from a bigger apartment? Sometimes all you need is your eyes to see that something looks a little fishy. We will definitely keep our eyes on this issue here at the Tenant Law Podcast, and there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.